Good morning, ladies and gentlemen. I'm going to call on Representative Labrie, who has graciously come to substitute to start us in the Pledge of Allegiance. All rise. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And I'd like you to remain standing so that we can take a moment of silence to pray for peace around the world. Thank you. No, thank you. I'm good. Well, I don't know if I'm good. Not bad. Okay. All right. So, I was notified that one of the bills that it was presumed that we finished, namely 1376, was finished, and it is not. So we are going to have to finish that bill. It is House Bill 1376, relative to a parent's ability to raise their child in a manner consistent with the child's biological sex. I'm going to give the opportunity to both sides to caucus on this bill, so that you know where you stand and what it is you want to do and how it is your caucus wants to vote on this bill. So I'm going to give, yes, Representative Scher.
Just for purposes of everybody caucusing, I filed an amendment, I passed out an amendment on this, a week or about 10 days ago. Obviously, I won't be moving the amendment, but I just want everybody, as they caucus, I want everybody to know about the amendment.
Okay, thank you for that information. That helps. Thank you. So I will give everybody, it's only one bill, so can we do it in 10 minutes, Representative Gray? Okay, we will resume at 10:15, please. So if the last person out the door can close the door, please. The audience chairs have to be empty, and we will resume at 10:15. Thank you very much. I'm sorry, I can't hear you, but don't use your mic, just speak up. this morning, we're going to go off of what the agenda says just a little bit. And we're going to begin with House Bill 1377. And Representative Corzine, do you have a motion?
I do, I motion this, ITL.
Do I hear a second?
Second.
Thank you. Motion made and seconded. Representative Corzine, would you like to speak to your motion?
I would, I think the bill's good. My fear with it is the 2 years that you can just sign your child over to another person for 2 years, without any kind of checks or any kind of assurance that they will get the education, their medical needs taken care of. I know that in cases of deployment, which were brought up during the meeting, it was stated that a deployment is 2 years, but they actually have access to lawyers for, to write up things like this, in cases of deployment. I just think that with all of the child trafficking issues and whatnot, 2 years is a long time to hand your child over to someone else without any guardrails.
Thank you. Representative Markell, would you like to speak to your second? And
Just to say that I agree with Representative Corzine.
thank you. Representative Scher.
I'm in support of this bill. I think it's a real issue. I think it's not as if that when somebody engages in one of these agreements, some stranger is being gifted a child for 2 years. It's that the parent of the child, the parents of the child get to pick who the person is. So there's that fundamental guardrail. Number two, it's not as if the parents are going to be incommunicado with that child and for those 2 years, even if it were 2 years. And so I think there are sufficient guardrails, and and I think Representative Long was very clear that in his experience, in his practical experience, something like this is needed, and I think it's well written in that regard. So I'm in support of this.
Thank you. You all set? Okay, Representative Levesque.
Thank you. I am also in support of it, mainly because right now the parents would have to go to the courts to get an affidavit signed by the courts saying that I'm leaving my child with this person for this amount of time. This way, it kind of saves the parents a little bit of time from having to set time out of their busy schedule of planning their trip or going off on their tour. This way, it's one less step that they have to do to carve out of their schedule. And I think the 2 years is important for military members, especially those that are single parents where the other parent has either passed away or has given up their parental rights. And this way they can leave the child with a grandparent or a family friend if they are estranged from their parents without having to go to the courts. And this way it's, hey, you can make the decisions for my kids in case anything happens to me in the meantime where I can't communicate. Like a lot of military members cannot communicate if they are in the Middle East or if they are on deployment where they can't talk to their families for an extended period of time. This way, if an emergency comes up where they have to take them to the emergency room, the doctor, or some emergency comes up at school, they can make those decisions the way that the parent would want.
Thank you. Representative Gregg.
Thank you, Madam Chair. So this is a bill that we've actually seen before. This is not the first time. We were all in support of it before because we understood the reason that you have, a 2-year plan. It's not because you can't take it back, by the way. Like say you think that you could be gone as long as 2 years for whatever reason, and it's only 6 months. That doesn't mean that you can't retract that back then and you've been in the court. So this is obviously extreme situation. If it was just for a little bit of time, you wouldn't have this. This is also, part of the parental rights part of this that we're assuming are a good parent and are designated somebody that is going to take good care of your child. Like that's that check and balance right there. If there has been no abuse or anything else, and if there has been abuse, first of all, DCYF is still going to pursue this. They're going to tell the judge or whatever, hey, this has been happening, because that communication with that parent who is not a good parent is still going to have to happen. But if you have, which we're going to assume parents are good parents, that for some reason needs a legal seatbelt for their children for 2 years because who knows what drastic situation has come up that they have to do this. This enables that to happen to keep everything in the best interest of the child according to their parent who's making those decisions for them. So I'm in favor of this bill. The only reason we did not get it all the way through before is because we didn't have a form. This time we have a form. Thank you.
Representative Pearson.
Thank you, Madam Chairman. While I have great sympathy for this bill, one thing troubles me, and that is there is just a sole sponsor. The rare occasions when I prime sponsor a bill, I try to work in a bipartisan way to garner as wide a support as I can. And maybe this bill could have that. But I would have liked to have seen several more Democrat co-sponsors and some Republican co-sponsors on this. And so I tend to back away from bills where I don't see that. So probably with some reluctance, I'm going to vote for the motion of ITL.
Thank you. Representative Love.
Thank you, Madam Chair. Although well-meaning, I think there's a million ways this could go sideways, and we don't have to look any further than that famous rock and roll singer up a little bit north of here. That the story is he purchased a 15-year-old. Not all parents are good parents, and we have to protect the children. And I'll be voting for the ITL.
Thank you. Any other comments? Seeing none, I will ask the clerk to call the roll.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart,
Yes.
Representative Nelson,
Yes.
Representative Love,
Yes.
Representative Corson, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Gray,
No.
Representative Jack,
No.
Representative Shear,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
No.
Representative Elberger.
No. No.
8-7.
George.
Will there be a minority report?
Okay, so the minority.
The minority,
Is OTP.
what is the motion?
It is ought to pass.
Thank you. That report has to be in before you leave here today. Thank you kindly. And the majority report? Oh. Well, I'm yes.
Chairman DeSimone,
Thank you. Yes, I even forgot myself this time.
sorry.
No worries.
What was the vote?
9-7.
9-7.
9-7.
I'll give the clerk a few minutes to get everything done and everything in place. And then we'll begin the next bill. The clerk is ready. I'll close the hearing on 1377, or the exec session on 1377. And I'm going to open the exec session on 1643. Representative Rice, do you have a motion?
Thank you, Madam Chair. I move ought to pass.
Representative Nelson.
Second.
Representative Rice, would you like to speak to your motion?
Sure. I just think that this is keeping it simple. The GALs are an investigative arm of the bench. They do not need to be making recommendations. Judges need to read the entire report and come to their own conclusion.
Thank you. Representative Gregg.
Thank you, Madam Chair. So I am actually ITL on this bill, but not because I don't think that there's a problem. I think this is addressing the wrong problem. On the special committee for the family courts on the last term, we did a lot of look at the GAL system, and I do think that it needs some help. I would actually, I think this should be interim study because I think while we're trying to address a problem, what we really need to be looking at is the issues that we heard about, which is inadequate training requirements and insufficient oversight in a complaints process. If they're not able to, let's just say because of their qualifications, make a recommendation, they shouldn't really be investigating this either. So I think that we are maybe throwing water on a gas fire here, but this isn't, with all due respect, I think that this is great to try to fix this. We also did pass a bill that was opening up who could be a GAL to like physicians and other people that have higher qualifications. We passed that, I believe, at the end of last term, so it's only had a year to really take effect. So we don't have a lot of feedback or information on that yet. So I just think this is best to interim study for now, but I don't think it's not something we can't bring back like in September or whatever after we've had the summer to look at it.
Thank you. Representative Pearson.
Thank you, Madam Chairman. As the chairman of the Special Committee on the Family Division of Circuit Court, first of all, I much appreciated the good and hard work Representative Gregg did on that special committee. But secondly, I would agree that what we found is that some GALs were wonderful, some were not. And for judges to rely a little bit too much on what they say is not a good idea. And we flagged that topic of GALs as something that would at some time, in some way, need further work. Thank you.
Thank you. Representative Scher.
Thank you, Madam Chair. I too think this should be interim study. It tries to fix the wrong problem. The problem is training for GALs. If the GALs are actually, the particular GAL is not thoughtful. But the premise of this bill is that the family court judge is an empty vessel who has no ability to do anything but what the GAL says. And that is just a bad, bad premise. And I think family court judges, many of whom I know, have the ability to read the investigation and also take into account the opinion of the GAL. If the GAL is an incompetent GAL, then the investigation the GAL has done will also be incompetent. So this really doesn't fix the problem. I agree with my colleague, Representative Gregg, that we need to interim study this bill and arrange for more formalized training and selection of GALs. That's the solution, not treating judges like empty vessels.
Thank you, Representative Rice.
Thank you, Madam Chair. So the premise of this bill was not that. The premise was they are an investigative arm of the bench. That's it. They don't need to be making recommendations. The judges are not empty vessels, but they can go in and read and make a decision off of the investigation.
Thank you. My comments are that, and then I'll call on Representative Corzine. Over the years, many, many years, we have worked really hard on what the GALs can and cannot do and what their relationship is with the court. Back many years ago, exactly what the representative said, they were acting as judge, jury, and executioner when it came to these to their job, and they are no longer allowed to do that. Their information is for the judge to explore, not the fact that they have any say in what the judge's decision is. So that's my experience. That's what we've worked on all these years. And next, I'll call on Representative Corzine.
Thank you, Madam Chair. I like this bill a lot. I will be voting for the OTP. We have to remember that the GALs sometimes come with no more than a 9th or 10th grade education. There's no education limits to be a GAL. And yet some are giving opinions based on nothing more than just, well, I'm a GAL, I get to do this. I think the judge should be the one making decisions, not a GAL, who oftentimes, as in my own case, was allowed to bring her own bias into situations. And I was just a foster parent. So I have seen this go very, very wrong. This is a good bill.
Any further discussion? Seeing none, I will ask the clerk to call the roll.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markell,
Yes.
Representative Labrie,
Yes.
Representative Gregg,
No.
Representative Jack,
No.
Representative Scher,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
No.
and, Representative Elberger,
No.
and Chairman DeSimone.
Yes.
Yes.
Again, I'm going to give the clerk a moment to get her paperwork together, and I will close this hearing. I'm sorry, exec session. And he'll second that. Okay. I've gotten the signal that the clerk is ready. I will now open the exec session on House Bill 1376. Representative Corzine, do you have a motion?
I move ought to pass on 1376.
Representative Pearson,
I would like to second it.
thank you. 1376 is now on the table. Do we have discussion?
Thank you.
Representative Corzine, would you like to make another motion?
Yes, Chairman, I have an amendment for 1376. I would like to move it OTPA.
No.
Nope,
You're
just
going to
the
move your amendment and give us the amendment number, please.
The amendment number is 2026-0865H.
I believe everybody has a copy of this amendment, and I will open the discussion for discussion on the amendment only. Representative Pearson. Okay, Representative Corzine, when you're ready, would you like to discuss your amendment?
I would. Thank you, Chairman. We should not live in a state where a parent is ever asked to set aside, surrender, renounce, or deny their own deeply held beliefs in order to keep their own child. I think a lot of people can agree to that. I think that when the bill came before the committee, a lot of questions were raised as far as the foster and adoptive aspects of this bill, which didn't clearly define that the best interest of the child would still be the priority in any placements. My amendment to the bill spells that out so that while the state cannot deny a foster or adoptive parents a license, they can still take the child's best interest at heart when they are being placed.
Representative Scher.
Thank you, Madam Chair. As everybody knows, I have another amendment that handles this in a different way. Hopefully that will be addressed subsequently. I appreciate Representative Corzine's efforts to clear up the problem, but I don't think the language of this gets to where we want to be. I think the way it would read better if it said parents who will who are committed to raising a child based on their biological sex cannot be denied a license. If it said that and only that, then I would be more supportive of this. But this is too broad, and it basically, for example, lines 5 through 11 make 5 through 7 really make it clear that it's still possible for DCYF to place a child who is struggling with their gender identity with a family who is committed to raising a child based on their biological sex. So that's problem number one. Problem number two is this isn't happening in New Hampshire. You know, I've spoken to DCYF, and there's no evidence that this is an issue in New Hampshire, and I think that we don't need to go there because this is not an issue. We heard from people from other states who gave examples of problems in other states, but that's not happening here. One of the reasons it's not happening is DCYF knows what they're doing in this regard and not overriding parents who choose to raise their children in accord with their biological sex. So I am opposed to this amendment, and again would love eventually to speak to the amendment that perhaps somebody else is going to offer.
Thank you. Any further discussion? Representative Pearson.
Thank you, Madam Chairman. in terms of it's not happening here, on other matters than this, where it isn't happening here, a bipartisan consensus of obviously the people I handpicked said, yeah, but we should get it into statute, because what happens when the wonderful people at, name the agency, retire and a new crew comes in with different ways of looking at things. So the fact it's not happening here now does not necessarily mean it won't happen in the future. So let's get ahead of it. And then secondly, in terms of matters of conscience, which is important to me, I have seen the opposite, where very convinced people from one extreme of the spectrum would deny people because of opposite reasons. And I would be just as much against that. So certainly this upholds the freedom of conscience. So that's my spiel.
Thank you. Representative Corzine. Since nobody else has, oh, I'm sorry. Representative.
Thank you, Madam Chair. I do have some concern about the first argument that Representative Pearson presented in terms of, well, we don't have that issue now, but maybe we will in the future. We can apply that kind of thinking to a whole lot of things.
Oh, yeah.
And do we say we're going to put somebody, and I'm deliberately choosing an extreme kind of situation here. We're going to put somebody in prison because they might commit a crime, so we're going to make sure they don't. I said I'm deliberately choosing an extreme. The fact that this might happen in the future can apply to almost any behavior we can think of. How many behaviors are we going to try to legislate against because they might happen in the future? I don't see that as a reasonable argument. Thank you.
Thank you. Representative Corzine.
Thank you, Madam Chair. Thank you for that. I do understand what you're saying. I want to say that it is happening here. Whether it's public or not, it is happening here. I fostered in Massachusetts for 20 years. I fostered up here for 2. And as soon as they found out that I was running for state rep, 2 of them became activists. And all of a sudden, our home was no longer good enough for this 16-month-old baby. This is absolutely happening here. We need to get ahead of this. We need to put it in statute that someone's deeply held beliefs are not a crime, and disagreement is not a crime, especially over certain ideological issues.
Representative Gregg.
Thank you, Madam Chair. So, I really looked at this because I was concerned about the level of abuse that we have in foster homes, which I think children, it's like 40% in foster homes can be abused. And so there's a couple different ways to look at this, but one, when we look at Section 3A on this, it kind of leaves the children a little bit more precarious situation when it becomes endangerment, because yes, foster parents might not necessarily agree with decisions the parents were making, and that was to be expected and stuff. But this right here would kind of leave an open hole for them to kind of get away with that endangerment. And also, in looking at cases of foster care abuse, there have been many more cases of abuse based on religious differences versus whether it be homosexuality or transgender. And so I'm wondering why we're picking the lesser of these that we're not having in this state to attack versus something, about religious preferences, because certainly those are even more deeply held beliefs in the system.
Thank you, Representative. Representative Pearson, and then Representative Scher.
Thank you, Madam Chairman. To make less vague my hypothetical, working with the judiciary in reforms of family court for almost 3 years, there were a few things that they adopted as we worked it out together and found this is good. It was the judiciary that said to me, we need to get some of those, or Representative, you people need to get some of these things into statute, because while we had a good working relationship, you won't be around forever and neither will we be. So even though these wonderful reforms are slowly taking place, their suggestion was get it into statute.
Thank you, Representative Scher.
Two things in response to what Representative Pearson said when he said their suggestion, that is the judges, is that they get it into statute. I'm not sure what the it is. Were they talking about the biological sex issue or something else? Number one. Number two.
Something else.
The risk here is that a child who has questions about their gender identity is going to be in a family that is not going to recognize them. And as we heard testimony, that one of the four possible consequences, at least to that. One is that the child internalizes it and nothing else happens until they turn 18 and they flee that family. Number two, the child engages in cutting, which it actually happens in families where there is a repression of discussions about gender identity. Three, it could be suicide. There is a history of that around the country. And four, there could be, there is evidence, as one witness talked about, of runaways occurring. So while I appreciate what Representative Corzine is trying to reach, I think the risks with this bill are so substantial, this amendment are so substantial that we should not adopt it.
Thank you, Representative Murray.
Thank you, Madam Chair. So yes, I also have some concerns about whether or not in the situation where an individual is placed into foster care, and it is true that not always the parental rights are severed, and there's oftentimes a constant communication between the foster families and the biological families on a myriad of different issues, whether it's doctor's visits, haircuts, acknowledgement of the identity of a child is included in that. And so I am worried that if this were to move forward in this way, it would set up or open the door for the potential for there to be some discrimination aspects of a child's identity in place.
Thank you, Representative Rice.
Thank you, Madam Chair. So this bill is just saying that you cannot deny someone a foster care license due to their beliefs in gender ideology. Okay? I would hope that the foster care system, the caseworkers are meeting frequently with these children to ensure they're in a safe and loving environment and that no one is trying to stifle their gender ideology. So, I mean, are we leaving kids in foster care for a year with no one checking in on them? I highly doubt it.
Thank you, Representative. I have a statement to make. I served on the Special Committee on Foster Care. We heard lengthy testimony concerning this issue, where the state does its best to make sure that children who have gender ideologies are placed in a home where they are helped to feel comfortable in that home. We also heard a lot of testimony about the fact that most of the families, the foster families, along with the biological families and the placement person from the state. Make sure that there are many conversations concerning the child's issues, whether they be gender identity or other issues. And the child is usually placed in a home where the foster parents can assist those children. And don't forget, many of these children are also involved in mental health therapy during their time in foster care. So I believe that this amendment and this bill are good. Representative Scher? Representative Gregg?
Thank you, Madam Chair. I appreciate you saying all this. So knowing that they are already doing this, knowing that even for a haircut, they have to consult with the parent, I'm just now back to being confused as to why we need this kind of legislation, because they're already working on all this, as you stated.
We discussed this in the special committee as well, and it was discussed then that in the future there should be legislation to be sure that, considering the fact that foster homes are at a minimum, that we are sure that no foster parent will be denied a license to love children. One more, and we're going to call the roll.
I understand this issue of this bill, this amendment tries to make it so that it only addresses being denied a license, but unfortunately, I don't think it reads that way. And
Thank you.
That's why I'm opposed.
Okay, thank you. That said, I would like the clerk to now call the roll on Amendment 0865H.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart, yes, Bogart,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Gregg,
No.
Representative Jack,
No.
Representative Scher,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
Yes.
Representative Elberger.
No.
And Chairman DeSimone,
Yes,
9-7.
that amendment passes.
I heard 10-6.
Oh, 10-6. Oh. Did you call on Levesque? Murray? I don't know. Georges?
Representative Georges voted yes.
Can you read the roll, Madam?
Okay.
Yeah. Representative Rice,
Are we on the amendment again?
No, I just want you to read the roll and how people voted.
Yes.
Representative Rice, yes. Pearson, yes. Bogart, yes. Nelson, yes. Love, yes. Corzine, yes. Markel, yes. Labrie, yes. Gregg, no. Jack, no. Scher, no. Levesque, no. Murray, no. Georges, no. Elberger. Oh, thank you.
Thank you.
Sorry about that.
So it's 10-6. The amendment passes. Do I hear a motion on another? Excuse me. As soon as the clerk is ready, I will call on Representative Levesque for a motion. Representative Levesque, do you have a motion?
Yes, I do. I move to accept amendment 0760H. I may speak on my motion.
Representative Levesque moves amendment 0760. Representative Gregg is seconding that motion. Representative Levesque chooses to speak on her motion.
So this just deletes sections 4, 5, and 6 and renumbering section 7 to read as section 4.
Representative Scher.
Thank you, Madam Chair.
We will only discuss this amendment. Thank you, Representative Scher.
This, I think, is a cleaner solution to the concerns some have expressed about either about the original bill and the amendment that's been adopted so far by simply keeping the 1, 2, and 3, that is page 1 of the underlying bill, and eliminating the rest so we don't run into the language problem that I think is a significant one in terms of does the current amendment only address licensing. So this was an effort to recognize the desire to not have somebody, a child who has gender identity questions, that not have that family be characterized as abusing the child simply by not recognizing that and raising the child by biological sex. I think that proposition we can all agree on. I think the rest is better for further study. So,
Thank you. Any further comments? Representative Corson.
Thank you, Madam Chair, and thank you. I don't believe this amendment goes far enough in protecting foster and adoptive parents. We've seen other states who have denied licenses. Even our neighbors to the south, Massachusetts, was denying foster and adoptive licenses. They have now come around and they're once again accepting them. Unfortunately, this amendment pretty much guts the whole foster and adoptive care issue in the original bill.
Thank you. Any further comments? Seeing none, I'll ask the clerk to call the roll. This is on amendment by Representative Scher, numbered 0760H. Thank you.
Representative Rice.
No.
Representative Rice.
No.
Representative Pearson.
No.
Representative Bogart.
no.
Representative Nelson.
No.
Representative Love.
Nope.
Representative Corson. No. Representative Markel.
No.
Representative Labrie.
No.
Representative Gregg.
Yes.
Representative Jack.
Yes.
Representative Scher.
Yes.
Representative Levesque.
Yes.
Representative Murray.
Yes.
Representative Georges.
Yes.
Representative Elberger.
Yes.
Representative. Nope. Chairman DeSimone.
Thank you, Madam Clerk. No.
7 to 9.
Representative Corson, do you have a motion?
I would like to make a motion of OTP on HB
Nope.
1370. Oh, OTPA. Sorry. On HB 1376. The amendment is 0865H.
Do I hear a second, Representative Pearson?
Yes, second.
Do I see any further need for discussion? Seeing no hands, I'll ask the clerk to call the roll.
Representative Rice,
Yes.
Representative Nelson,
Yes.
Representative Pearson,
Yes.
Representative Love. Representative Corson, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Bogart,
Yes.
Representative Gregg,
Motion's OTPA, right? Sorry. No.
Representative Jack,
No.
Representative Shear,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
No.
Representative Elberger,
No.
Chairman DeSimone.
Yes. Will there be a minority report? That report shall be to the chair before we leave today. Who's going to do the minority report? Okay, thank you. I will give the clerk a minute to get her paperwork done.
Oh, great, thank you.
I'm going to close the exec session on House Bill 1376.
Yeah, we should. We should.
I just want to pull this bill.
Oh, okay. Well, she'll do that because I think she can have that. So you're 12:31,
Yeah.
you're making.
Okay, Madam Clerk is ready. Chair DeSimone would like to make a motion of ITL on House Bill 1241 and Representative Nelson.
Second.
Representative Nelson seconds, and I choose to speak to my motion. This bill has come before us, and it amends the definition of gross income for the purposes of support orders in divorce proceedings and prohibits gross income calculations from using overtime compensation, secondary employment earnings, or other income derived from sources outside the primary employment. So I've checked into it and done some research. And what happens is that when you fill out your child support orders, you submit your 1040 for the prior year's support, the prior year's income, and you also submit, as a rule, I believe it's up to 4 current paychecks that you can use as proof as to the differentiation of your income. So let's say last year you had you had 2 jobs, so your income level was significantly higher than this year because this year you only worked 1 job. Last year you worked significant overtime at one of your 2 jobs, but this year you're not working much in the line of overtime. So you can submit the evidence to the court insofar as what your income is at the time of the calculation of child support. So I feel that this bill that wants to prohibit all of that overtime compensation and secondary employment is already being addressed. So this bill is totally unnecessary, and that's why I have motioned for ITL. Any further comments? Representative Markell.
Yes, thank you, Madam Chair. Also agree, as a practicing family law attorney, it's been my experience that RSA 458C, which is the child support guidelines, also deals with income, whether it's significantly high or significantly low. Also allows sufficient discretion of the court to consider overtime. As a general proposition, overtime, which is sporadic or not recurring, is usually not regarded or taken into consideration in terms of determining a child support order. So if somebody were to work seasonal overtime, such as for a seasonal worker, let's say somebody works at UPS and has 2 weeks around Christmas every year for the sake of argument only, to deliver packages, and that doesn't recur during the rest of the year, courts are free to disregard that. As regards to alimony, which is the other part of this particular bill, that's the child support guidelines. In the first part, we see here RSA 458-19-5 being addressed. It already deals, that statute already deals with part-time jobs and so forth, which occur after the initial order. Courts have discretion to include income as it is in that statute. So I concur that this is really unnecessary and duplicative.
Thank you, Representative Love.
Thank you, Madam Chair. Key words here, usually, may. The court isn't mandated to do a whole lot. And like Representative Pearson mentioned on a previous bill, they're begging for statute. This bill will give them some guidelines. This is what you have to do. Let's not rely on usually and maybe, and maybe they could and maybe they will, maybe they won't. Let's give them guidelines. We have plenty of complaints, time and time again. People feeling they've been wronged. Common sense tells you a lot of things, and it's not followed a lot of times. Let's give them the guidelines. Thank you.
Thank you, Representative Rice.
Thank you, Madam Chair. I think in the cases of child support and alimony, the judges need that leeway for discretion because I think every individual case is different, has different exceptions, different everything. So to give them that leeway rather than locking them in on something, I don't think locking them in is the right move.
Representative Levesque.
Thank you, Madam Chair. I also see an issue when it comes to salaried employees because we do have some businesses where they are salaried and it's not included with that when it comes to the calculation of everything because their hours are different. They may work 40 or even 60 hours and they're salaried. Their overtime is calculated different than all the rest of the employees. So I think that not including them in this bill would disservice them because the judges will get there and be like, okay, you're salaried. This kind of constricts them too much. And I think that the law that we have now allows for salaried employees their income kind of allows for their income to be included with that. So I think that that's an issue that was brought up during the committee too.
Thank you. Any other comments? Seeing none, I will ask the clerk to call the roll.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart,
Yes.
Representative Nelson,
Yes.
Representative Love,
Nope.
Representative Corson, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Gregg. Representative Jack,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Murray,
Yes.
Representative Georges,
Yes.
Representative Elberger,
Yes.
and Chairman DeSimone.
Yes. Pearson.
Representative Pearson?
No, we're done. I'm asking
That's what I
to
thought.
be
Yeah,
recognized to make a
We,
motion.
I need the numbers first, Representative Pearson. And then
15.
the numbers are 15-1. Representative Pearson, do you have a motion?
Could we put this on consent?
Without objection? Representative Love?
No objection.
Thank you.
Thank you. Consent it is. Representative Love, can you shut your light out? No worries. We're, I'm going to close the hearing, the exec session on 1241, and I will open the exec session on House Bill 1263. Representative Markel, do you have a motion?
Yes, Madam Chair, thank you. I move that this bill be ITL'd, and I will provide reasons if the committee requests it. Yes.
Representative Gregg will second.
Okay.
Representative Markel, would you like to speak to your motion?
Yes, Madam Chair, thank you. The reasons for ITLing this bill are a couple. Number one, we already have existing marital statutes to cover it. RSA 458-16A deals with division of property. Military retirement is actually, I'm sorry, what? Oh, okay. As retirement pay. Basically, there are two aspects to this. Number one is that a pension which vests, pensions are property, and they are property rights, which are considered intangible property. And under 458-16A, courts for equitable division purposes can consider property which is tangible and intangible, personal or real as well. In regards to a military pension, I'm going to just get you what it is right over here, is that the Uniformed Services Former Spouse Protection Act allows the courts in domestic relations matter to consider the equitable division of that particular type of pension. And it also allows a court, a family law court, to consider the division of the military pay itself. So those are the two parts of a pension. So on that basis, and finally, just to wrap that up, when you look at 458-16A, it indicates in part to the extent allowed by federal law. Therefore, Congress in passing the Spousal Protection Act has specifically exempted family law and domestic relations from the preemptive effect of federal pay in this regard. So on that basis, this would hamstring courts to be able to do justice because domestic relations matters are by and large equitable proceedings. And finally, in closing, it doesn't mean that a court must award a pension or must award pay from that pension. So on this basis, I'm going to suggest that the committee ITL this bill. Thank you.
Thank you. Representative Love.
Thank you, Madam Chair. You know, the problem here is this a pension or is this pay? Because there are contingencies, because there are stipulations that a retiree has to live by. He can't go out and do dishonorable things, commit crimes and stuff. He will lose this retirement pay. If he works for a foreign government, he will lose the retirement pay. There are stipulations. You know, there's things they can do and they can't do. Therefore, it's not your typical pension. Okay. It can be used for child support. It can be used for alimony. Okay. It shouldn't be something that you get half of as you know, as a home, you know, as something of equity. It's still a job. You have to stay available, you know, to go back into the service. You know, because the stipulations like that, to me, it's a contract with the United States government that you will be ready and available to return to service, that you won't act like a criminal, that you won't go to work for a foreign government no matter how much they're going to pay you. You know, there's stipulations, and it's not your typical pension. Like if I retired from the Teamsters, if I retire from the Teamsters, I can open up my own trucking company, steal Teamster jobs, and I still get that pension. Okay, this is much different, and you know, we've got to treat it that way. You know, this isn't a male and female thing either. There's plenty of women retiring from the service, and you know, this yeah, I think it should be treated as a pay, not property. Thank you.
You're welcome, Representative Gregg.
Thank you, Madam Chair. So I think on this particular thing, and also I want to acknowledge that in any divorce, if it's not the kids that becomes a big sticking point, it's the retirement that becomes a big sticking point. So just as my colleague stated, this is not, you know, a typical situation. There isn't anything that people in our armed services do that's really typical for the rest of us. They make this huge sacrifice, and it's not only the service purpose in making the sacrifice, it's the spouse, it's the family. What you have is situations where spouses are married to a service person. They quite usually do not have the ability to get any kind of retirement from their own occupation they might have because of the constant travel, because of the constant, you know, up and move. Maybe they're a teacher in one district, but they go from Illinois to Hawaii or wherever else. They're not able to build their own retirement. So to say all of a sudden that the service person should be able to hold their retirement while their spouse, for whatever horrible reason their marriage could not survive, can no longer be entitled to that when they were not able to build up their own kind of retirement because of the lifestyle sacrifices that this makes, is just it's a bad idea. So I'm in support of the ITL in this.
I'll call on you after everybody else has had their first chance to speak. Representative Love. Okay, remind me, please. Representative Levesque.
Thank you, Madam Chair. Yesterday I did pass out some information from both the Army website and a military legal website. The military legal website one outlines the former Spouse Protection Act a little bit more further for anybody that does want to read it. I think that a lot of people focus on the military member a lot, which I think is commendable, but they also forget that the spouse is also sacrificing a lot too. My mom is a spouse of a military member. My dad was Air Force. She did not travel a lot. She went from Barrington to Pease. That's as far as she traveled, but she knows a lot of spouses that traveled a lot further. My dad had an opportunity to travel to South Korea. He chose to be dishonorably discharged instead, so he can focus on being with his family and growing his family with my mom. I think that some of them that did continue, I think it it takes a toll on a family to be and part of the military. A lot of people don't realize, like, you're constantly moving, you're having to um, bring up, like, take all of the moving boxes out again and then live your life to somewhere else. And I think that the military spouses, without them, a lot of the military members would not survive without them there. So I think that having that family there with them helps them a lot. And I think the spouses do sacrifice a lot too. They sacrifice promotions, they sacrifice their own career. And I think that, you know, the federal law outlines and shows, like, hey, we understand you sacrifice, so we're going to give you this. And I think that trying to get around it is really, really hard to do, because when it comes to the military, Congress is pretty clear on things. So
Representative Corson.
I have a question I was hoping somebody could answer.
Sure.
If the spouse is awarded this pension or not pension, disposable military retirement pay, is it for the entire service career of the veteran, or is it only for those years in which they were married?
That's a very good question, and there are two answers to that question. Okay, the first is ordinarily there is something called, when you're dealing with defined benefit plans, which is what military pension kind of things are, is done under the Hodgins formula. Okay, which considers the amount of the pension that was acquired before the parties married, and then will equitably divide the portion that was earned during the time the portion that was married. Sometimes that's referred to as the coverture portion. However, that said, in, I think it was June of 2025, the New Hampshire Supreme Court decided Legault. And Legault looked at the statute and said, wait a minute, we're going to make the entire marital pension subject to equitable distribution. While it did not expressly overrule Hodgins, what it said is there are some, and I don't want to get too far afield from it, what it said is courts, based on RSA 458-16A, can, because it considers everything that goes into the marriage, can now look back at the entire pension and, under certain circumstances, make it subject to equitable distribution. I hope that answers your question. And just one last thing is that I did hear it mentioned about what the non-military spouse does. We also should be aware that courts and statute also recognizes economic but non-economic contributions to the marriage. So we look at who kept the home, who raised the children, who cooked the meals, who did things around the house. So it's equity. Thank you.
Thank you. Representative.
Thank you, Madam Chair. I have a question because I haven't been able to figure it out from the text here. When child support is awarded, does that child support terminate when the children reach 18?
Yes. Unless there is some sort of a disability or an agreement, or they're in college, just like a civilian. It's treated just as a civilian child support would be treated.
Thank you.
You're welcome. Representative Nelson, and then Representative Georges, and then we have. Go ahead.
Thank you, Madam Chairwoman. In my research, and I'm hoping that maybe Rep. Markell can just say yes or no if this is true, but in my research too, because I've found that because retirement pay is regarded as marital property, sometimes there are agreements such as, you know, no, like agreements when things are getting divided, right? So there might be something where the portion taken from the retirement pay might be a larger portion than just because there might be Okay, forget it. Forget it.
Now I
Sorry.
think, no, I think it's, Representative Georges, then Love, then, Markel.
Thank you, Madam Chair. I just, because of the research, what Representative Levesque asking, what he gave, I just wanted to read that thing because that's making me a little bit. It's a supporter of a defendant under Army Regulation 608 by 99. You say here, interim minimum financial support. But I'm just going to read just this. The specific amount of the financial support will depend on the number of family members, whether the soldier is supporting more than one family unit, and whether the husband and the wife are both in the military. And if they said both they are in the military, that means even the pension is for both.
Thank you. Representative Love.
Thank you, Madam Chair. Just to rebut a few things, we've heard about how military spouses forego, their ability to climb the corporate ladder, to have their own pensions. In this day and age, when we have IRAs, they come with you. Okay, very rarely, okay, do you see people working for 7, 8 years for the same company? Okay, they're pretty. It's pretty common for most folks to work for 3 or 4 years for one company and move on to another and get a better job. And the more education you have, it isn't your pay isn't based on seniority anymore. It's based on your education, and that kind of takes the that whole premise that that you're foregoing anything and shoots it in the foot. Okay, there's plenty of opportunity. Okay, we heard testimony from an Air Force colonel that testified that his wife was sitting on the beach in France while he was getting shot at. Okay, bullets going by the cabin of his plane, and she gets it for gets the portion that she was awarded for life. Okay, I can see alimony. Okay, yeah, that's what he testified to. Yes, others said the same thing that he's been divorced for 17 years. He said, and his wife is still getting part of his retirement pay. I'm sorry, that's wrong. I can see alimony. I can see helping them, get their life back together, and everybody lives happily ever after. But for having forever, if I was who in the military get married with that stuff, it just,
So I just want to make a statement on that round, and then we're going to take one more round of statements, very quick statements, and then we're going to call the roll. But women or men, and in this case, I'm just going to use women to be easier. You're married to a man who's in the military. You work at a job here for 2 years, and you may end up with a very small 401k or retirement. And then you move on and you have to work for, in some cases, up to a year before you can begin your retirement plan again, so forth and so on. So the issue here is this. If that's the case and they can bring it with them, that's okay. Because during the divorce, the income and the financial holdings of the spouse are considered as a deduction from the income and financial holdings of the other side. So it is fair and equitable. And I looked at this through another lens of, what about first responders? Their retirement is considered when divorce comes. What about any other human being? I applaud, I love, I admire. Nobody thinks more of a military person than I. But it's a job they chose. It's a job that they and their wives chose. Therefore, whatever financial holdings there are at the dissolution of a marriage should be considered during the divorce. And in New Hampshire, we don't give lifetime alimony anymore. That has changed many, many, many years ago. So I don't know that these people were living in New Hampshire when they got those alimony awards. We didn't question that when they were here. So I don't know that they did, and I don't know that they didn't. But the point is, we don't do lifetime alimony anymore. Representative Markel.
Thank you, Madam Chair. Well, I think it's important to note that these rules are not mandatory. It's only what a court can consider. That's all it is. Let's not read more into this than there really is. For example, somebody can say, look, I'll tell you what, you can have this, just don't touch my pension. And if the parties agree, done deal. Thank you.
Thank you. Okay, with that, that was great. Okay, 2 seconds.
I just want to rebut a little bit what you said there about alimony. This is, if it was treated as alimony, that'd be okay. Okay, this is treated as a house. You get half of it. Okay, it's a package that here, this is yours. It's not alimony. As far as the first responders go, they don't have to come back to service after they retire. A military guy does, a woman, that they have to come back if they're called. Okay, this is a contract with the government for pay. It's almost like a job.
Thank you. All that said, will the clerk please call the roll on the motion of ITL on House Bill 1263?
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart,
Yes.
Representative Nelson.
Yeah.
Representative Love. Representative Corzine, yes. Representative Markel,
Yes.
Representative Gregg,
Yes.
Representative Jack,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Murray,
Yes.
Representative Georges,
Yes.
Representative Elberger,
Yes.
Representative Labrie,
Yes.
and Chairman DeSimone,
Yes.
15-1.
Will there be a minority report representative?
No.
Representative Pearson, do you have something?
Why, thank you, Madam Chairman. Yes, could this go on consent?
Without objection? No objections? Consent it is. I'm going to give the clerk a moment to get her paperwork in order, and then we'll move on to the regular calendar. Um, 13. I'm going to close the hearing on 1263. Why do I keep saying that? The exec session on 1263, and I'm going to open the exec session on House Bill 1378. And I'm going to ask Representative Corzine if she has a motion.
I'd like to make a motion of OTP.
And Representative Rice seconds that. Representative Corzine, would you like to speak to your motion?
Yes, I believe we should pass this because parents need reasonable access to their children's medical records. Parents are the ones who are going to put all of their medical care together at a time when a child might go see several different specialists. You need a parent to know what their children are taking, what the side effects are, what they should be looking out for. They need that access to their child's records that's convenient for them.
Representative Rice.
Thank you, Madam Chair. We've also heard the argument that they can't redact if it goes into the portal. I'm willing to bet if we pass this legislation, they'll learn really quick how to redact that information.
Representative Scher and then Representative Gregg.
Thank you, Madam Chair. I don't know if people know, but parents already have access under state law to medical records. It's limited by what federal law says, and this bill goes beyond federal law and therefore puts a provider in a very difficult position, and we don't need to do that. I think, it's very, very, very unusual that parents won't have access to something that they want access. Under federal law, you can know that your child is having psychological services, but you don't have access to the notes of the provider. That's what federal law says. And this bill goes way beyond that, and therefore, one, it's not needed, and two, it to the extent it tries to overrule federal law, that's not going to happen.
Thank you, Representative Gregg.
Thank you, Madam Chair. So I was not able to be here, but was watching online. And so we had the mother here who had the large stack of things that she got from the electronic, not records, but what you see online that's not really medical records, the portals that we have. It's got some information, but it's not the full records. And she stated that she was able to get those, but that laws have changed. No laws have actually changed. We're still able to get those. I know for my children, I still, as adults, they still would rather me take care of that. So while I understand that this is a need to maybe control what our children are doing in certain areas, this is not really the answer to the medical records, because it is, while it does have some information, it does not have records on there.
Representative Levesque.
Thank you, Madam Chair. I think that this is a really big overreach to where it kind of shows that we don't trust parents to have these open conversations with their kids about their medical information. You know, even today, like I'm almost 27 years old, I tell my parents if I'm on a new medication because I'm living with them right now and I don't really notice any signs, so I want them to be able to notice the signs or anything. I have that open conversation with my parents. I always have. They've had it with me. And even like, I think that having that open and honest conversation with your kids about what's going on with your medical needs and everything, I think they already do. I'm again not a parent myself, but I think that if they don't have access or if the kid feels the need to hide something, there's either a really good reason why they need to, because either the parent is not as supportive as the kid wants them to be, or they're just not ready to tell their parent something, you know. And I think that it's up to the kid of when they're ready to tell their parent. But I think a lot of parents and kids have that open discussion of, hey, I had a doctor's appointment. Here's what happened. Or for me, my doctor's office gives us a full printout. I give those to my parents of like, hey, this is what happened in case you're wondering. And they having that open conversation is really important. I don't think this is the way.
Representative Rice.
Thank you, Madam Chair. So, just to speak about the federal law, that federal law is, I believe, an Obama-era law that came along with Obamacare. So if that woman had all those records, I would assume it was prior to that because she did say her daughter is an adult now. And I just think, I honestly believe parents need to know all medications their kids are on. Nothing should be hidden from them because they could be having a reaction. A parent doesn't know what's wrong. I just think it's a big mistake.
Representative Nelson.
Thank you, Madam Chairwoman. While I agree that children and parents should have an open and honest relationship, my point of view is not that. I can tell you I have an experience that's happening right now where my son has had a major injury and I had to get a proxy account from the orthopedist so I could go on and discuss medical notes with the people down at Boston Children's Hospital. Although the doctor sent records to Boston Children's Hospital, there was still some questions here and there that I was able to answer because I was able to go on, as a proxy onto his account with the orthopedist. And it's not that my son wanted to hide things from me. He's 15 years of age. He's incapable of the executive functioning to coordinate his proper care. And so I do also get concerned that we're getting a little bit in the weeds of parents wanting to control. I discussed in our hearing that I'm able to see a lot of things when I get the explanation of benefits, what testing was done, what medications were prescribed. But those are some pieces of the puzzle. But if I can't see some of the medical notes, that could be an issue. And obtaining medical records by law can take up to 30 days to receive. So with that, in that amount of time, there could be something that could be going on, like a reaction to a medication, and I might not know exactly why. And thank you. That's it.
Is it Representative Markell, then Chair, then Pearson?
Thank you, Madam Chair. I do note that under RSA 461A, which is the Parenting Rights and Responsibilities Act, parenting plans are generated. Within the scope of the parenting plans, and it actually becomes a court order, parents have a right to access to a minor child's records, and that includes notes and a whole bunch of other things. So what we're actually saying here, under the law as it is now, if you are in a family which has been disrupted and you are in a parenting plan situation, your rights are actually superior to somebody that, in terms of raising your children, particularly if you have shared decision-making. Your rights are actually superior to somebody who's in an intact family. And I'm assuming that this statute passes muster for those reasons with HIPAA. And if we need a statute to be able to cure a hole in the law, then I think we should be putting parents in intact families at least on the same footing that parents who are in disintegrated families at the same level. Thank you.
Representative Scher.
Thank you, Madam Chair. To address what my colleague, Representative Nelson, said, you can get all of that information now. The proxy account is a it's a way to ensure that you are the parent and can have access to your child's account. So you'll still have to do a proxy account even if this passes. So I just don't think this is needed, and it confuses things given the status of federal law.
Thank you, Representative Pearson.
Thank you, Madam Chairman. For the purposes of this bill, it's irrelevant whether we think the federal law that says certain communications between a tender-aged child and his or her physician is privileged communication. That's not this bill. This is about adding portals. I probably am the only person in this room who's the spouse of a doctor who treats minors. I'm probably the only person in this room who's the CEO of a medical center. So let me tell you, if this bill were to pass, we may shut down our portals. It will take a lot more work than redacting paper copy or electronic. In the last 24 hours, I've been in touch with some medical people, and they agree. They may well shut down their portals, and that would be a loss. So let the portals be used for what the portals are for, and we've already said it is not as extensive as paper records or electronic. And let's let the status quo continue to go. And if we do not like privileged communication between a doctor and a child, then that's the bill that needs to come forward.
Thank you, Representative Nelson.
Thank you, Madam Chairwoman. To address my colleague, you need your child's permission to have a proxy account. So, you know, I have an open relationship with my son, and he was fine with it, happy that I was taking care of him. But my problem is that if there are strained relations between you and your child, I'm not talking about having access to things that are not allowed to be accessed to per law. It's a sticky situation because as parents, we are required to care for your child. And you know, until the age of majority. And my concern is that what happens if there's a reaction to a medication, or the medication isn't refilled, or some other major catastrophe happens? Will the parent be looked at as neglectful because they did not give their child access to proper care?
Representative Corzine.
Thank you, Madam Chair. We cannot hold parents accountable for a child's well-being. We cannot expect parents to pay for their medical bills, pay for their insurance. We cannot expect parents to do all of these things while covering their eyes to their child's medical issues. That's not fair. We're blinding parents by not giving them this access. If my imaginary daughter at 16 comes to me and says, "Oh, my leg's been hurting today," you know what? I'm probably going to tell them, "Go lay down." But if I know that she's now taking a medication that maybe could cause deep vein thrombosis or something, then my daughter comes to me and says, "Oh, my leg hurts." That's a very different situation. And if a parent doesn't know what that child's taking, you're putting not only the child at risk, but you're putting their whole relationship at risk. We cannot hold parents accountable, but not let them see into this aspect or this issue. It's not fair. It's not right.
That's a federal issue.
We heard just in session a couple weeks ago that, you know, the frontal lobe isn't fully formed until someone's 27. By the same people who now want to be able to keep secrets about a 12-year-old's medical files.
Thank you, Representative.
Thank you, Madam Chair. I've actually heard that the age at which brain is fully formed is more like 33, which is even scarier because most people at that point are driving cars, drinking, potentially have children, so it's kind of scary to me. I also know that when a child is having a problem with a parent, requiring information that may be shared between that child and a therapist to go to the parent may be what the parent wants, but may not be in the child's best interest. There is a reason that we try to have friends around us who can respond to our children in ways that we may not be able to. And I would hate to suggest that we should be allowed to have access to any information about our children when it may be detrimental to our children's health.
Thank you, Representative Gregg.
Thank you, Madam Chair. I would like to respond to my colleague from Coas County. I am concerned that we continue, this is not the first time it's been brought up, because one representative on the floor of the House decided to say something that maybe some of us don't agree with, and myself included. I don't appreciate the assigning motive continuing after that. So I would appreciate if we stop that. Thank you.
Thank you. Any further discussion? Representative Georges?
Thank you, Madam Chair. I just want to give my own example when my daughter was going to the therapist when we were divorced. I'm the one sent my kids to the therapist because we was going to the divorce. The divorce was really like it was hating my kids, and I put my kids in the therapist. But when they was talking with the therapist I never be inside. I always be outside. But they don't tell me. They was not let me ready to know what was going, and sometimes too they don't want me to be inside. My kids was refused, and that was their private. That was the way they want to feel, and it was good for me. I'm the one who put them, but they didn't want me to be inside.
Thank you. One more comment. It'll be Representative Scher, did you raise your hand?
I did not.
Representative Love.
Thank you, Madam Chair. Just want to tell a short story. My sister underwent a medical procedure when she was 14 years old that my mother and father had no idea she was doing. It affected her mentally, physically, all that stuff. They had no idea. She spent the better part of her life bouncing in and out of the Danvers Mental Hospital in Massachusetts, Danvers State Mental Hospital. She literally drank herself to death over it. Okay? If my mother and father knew, even afterwards, maybe they could have loved her into sanity. I don't know. Maybe they could have helped to get the help that she needed way before she ended up in that mental facility. Parents need to know what's going on. When something happens to a child, the doctors aren't there for the rest of the child's life. The teachers aren't there for the rest of their life. They're all merely but visitors. If something happens to my kid at 14 years old, I'm there for the rest of my life taking care of that child. Okay, and to block parents from any information, any medical information, is just flat out wrong. Thank you.
Thank you. That said, we're gonna call the roll. I think we all know how we're gonna vote. Thank you. Madam Clerk, will you call the roll? The motion is ought to pass.
Representative Rice,
Yes.
Representative Pearson,
No.
Representative Bogart,
Yes.
Representative Nelson.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Gregg,
No.
Representative Jack,
No.
Representative Scher,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
No.
Representative Elberger,
No.
And Chairman DeSimone?
Yes.
Date it fails.
I think it's 8-8.
It is.
8-8.
Okay, so whatever, we just need to say what it is. Who's gonna do the?
So first, I will let you know the count is 8-8. Therefore, it will leave this committee without recommendation. There will be a statement from the majority and a statement from the minority. Okay.
But statement in support of
A
OTP.
statement I apologize. I was thinking about the fact that Republicans are in the majority. But a statement on either side of OTP and ITF. Okay?
So however you want to fill out the report, whoever fills it out, you can cross out whatever.
I have this. Still, yeah. Oh, sorry.
Thank you. I'll close the hearing on 1378. And when the clerk is ready, we can. Yep. You ready?
Yes. I am.
We're going to open the exec session on House Bill 1565. Representative Corzine, do you have a motion?
I do. Motion ought to pass.
Representative Nelson.
I second.
Representative Corzine, would you like to speak to your motion?
I would. I recommend this ought to pass because a lot of people like to weaponize DCYF right now. This actually makes a really good, this actually puts forth a difference between encouraging people who are sincerely afraid for a child versus those who may be doing it for some ulterior motive. While this bill punishes malicious actors, it does focus on real risk and allowing those people to still encourages them to still call DCYF as a mandated reporter.
Thank you. Representative Gregg.
I would like to say I appreciate the fact that how damaging malicious false reports can be. And I understand that we're struggling to figure out how to maybe bring that down. But as far as this bill, it's not going to change anything because it still allows anonymous calls. And so with that, I'm not sure, how this would change anything. And it doesn't matter if they have caller ID or not. You can star 67 and not show your number or whatever. So the problem is that, yes, we do have an issue, but this is not the solution for it. It's the way that it's written, it's still going to allow anonymous calls.
Representative Love.
Thank you, Madam Chair. Regarding the anonymous calls and stuff, we do have voice recognition technology now. And if somebody is calling in, 3 and 4 or 5 times, those calls are recorded and they can be charged. This has been a problem for as long as DCYF's been alive, I think. They come in and they make mistakes. Sometimes they get it right, sometimes they get it wrong. But all the time, kids pay the price. All too often, we forget about that. The kids are paying a drastic price. Often life-changing prices that they've got to pay. Let's work towards the truth. When we go to family court, when we go to these, let's have them working with the truth, not with the lies.
Thank you.
Help them decide.
I want to let the committee know that this bill passed before. It went to the Senate and it went to a committee of conference because the Senate decided to attach 3 bills to this bill that had nothing to do with this bill, one of which was to hang portraits of certain people in the State House. So the conquerees decided to not act on the committee of conference because the other 3 items that were attached to it were absolutely unnecessary to do. We tried to talk to the other side of the wall and ask them to take those things off, and they flatly refused. So that's why the bill never made it to the governor's desk. It did pass before in this form. This particular representative who's talking right now believes that this is an important bill. So I just wanted to give you the history. Who raised their hand next? Somebody over there. Representative Scher.
I think the key word in this bill is on line 10, which says reports made to the department may include the name. It doesn't require it, so it really, this does nothing. It still allows for anonymous calls. It's just I appreciate what we want to have happen in terms of harassment calls to DCYF, but this bill just does absolutely nothing given the word may. It only would do something if the word was shall. So I'm going to oppose this until we do something better.
Thank you, Representative. Representative Rice.
Thank you, Madam Chair. So I just think that it says may, because if they start seeing a pattern, then they can ask for that same person's name and information. If they keep seeing the same number coming up or they keep recognizing the same voice, then that gives them the authority to ask for that information by having it may. By removing shall, we have left protections for people who are making the good and honest reports to be able to be encouraged to still do it anonymously.
Representative Nelson.
Thank you, Madam Chairwoman. I have 3 things, 3 topics. Quickly, 28 states already have this in statute, red and blue. The fact that this would be a law will be a deterrent to some people. And there have been claims that nobody who is making a false report will use their own name and true information about themselves. And actually, there is evidence that there are a lot of people who do use their names because they are trying to get leverage in a custody or divorce case, anger during a dispute, revenge, harassment, and they do want to have their names be recorded.
Representative Murray.
Thank you, Madam Chair. And just this is a question for, I guess, the chair. I'm looking here on lines 10 through 12 where we were talking about the name and address being disclosed, but nothing in those 3 lines that I can see directs a department to charge them with requiring them to ask for that. Am I missing that somewhere else?
Because we didn't want to require unless they felt the need. They don't require it for every call. Sure.
Madam Chair. And so I guess my question is then, are we putting that person who's receiving the phone call in a position where they legally might be at risk for failure to ask a question or not ask the question?
No, we're not. Representative Corzine.
Thank you, Madam Chair. I don't know if anyone remembers last year when the bill was first testified on, but we actually had the DCYF people here during the hearing, and they testified to the fact that even if somebody leaves an anonymous tip, they have ways of tracking phone numbers, and if calls come from the same number very often, it's flagged. DCYF was here and said that that was all okay.
Representative Scher.
just to address what Representative Corson said and what Representative Rice said earlier, they can do all that right now. There's just no need for this. Everything that Representative Rice wanted to happen can happen now. This doesn't enable that even more. It's just empty. And I appreciate the spirit, but this doesn't do anything more than they can already do.
Thank you. Representative Pearson?
I'm not a lawyer, I just play one, and maybe the lawyers here can help me on this. If after recognizing a certain phone number coming up again and again, the person at the call center asks for name and address with a view of prosecuting, is that a Fifth Amendment violation?
No.
No.
Okay, that's why I'm
No,
not
it
a
isn't.
lawyer and only play one.
No, it is not. I did check the constitutionality
Thank
of
you.
it, and it does not.
Okay, good.
That is something.
We are very proud of you both. Seeing no other hands, I will ask the clerk to call the roll.
Representative Rice,
Yes.
Representative Pearson,
Yes.
Representative Bogart,
Yes.
Representative Nelson.
Yes.
Representative Love. Representative Corson, yes. Representative Markel,
Yes.
Representative Labrie,
Yes.
Representative Gregg,
No.
Representative Jack,
No.
Representative Scher,
No.
Representative Levesque,
No.
Representative Murray,
No.
Representative Georges,
No.
Representative Ellenberger.
No.
Chairman DeSimone,
Yes.
9-7.
Will there be a minority report?
Yes, I'll be doing it.
Thank you. I'm now going to close the hearing on House Bill 1565. And I'm going to open the exec hearing on House Bill 1757. And Representative Nelson, do you have a motion?
I do. ITL.
Representative Nelson has moved ITL. I second that. For discussion, do I see any hands? Representative Nelson would like to speak to her motion.
Thank you, Madam Chair. Creating a law requiring marriages that existed for less than 5 years to not be eligible for consideration for alimony just isn't feasible. There are valid reasons why alimony should be considered for shorter term marriages, including disability or serious health conditions, family violence, career sacrifice, caring for a child with special needs, or financial misconduct. If this bill were to become law, the court wouldn't have discretion to make considerations for circumstances like that. And also in my research, I've discovered that other states would have recommendations or considerations, and generally they look upon, well, you probably know better, but, look upon, like the 10-year being married as a starting point, but you need to have flexibility in taking into consideration special considerations, and for that reason, that is why I support IT.
Thank you. Representative Markel.
Yes, thank you, Madam Chair. The Alimony Reform Act that took place earlier, I think it was 2019 more or less, already deals with these issues, and it provides for short-term marriages where you can go up to 50% of the length of the marriage. So I don't know why you would have a disqualifier for it. Makes no sense. I don't think it's needed. Thank you.
Thank you. Seeing no other hands, I will ask the clerk to call the roll.
Representative Rice.
Yes.
Representative Pearson. Representative Bogart.
Yes.
Representative Nelson.
Yes.
Representative Love.
Nope.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Labrie.
Yes.
Representative Gregg.
Yes.
Representative Jack.
Yes.
Representative Scheer.
Yes.
Representative Levesque. Representative Murray.
Yes.
Representative Georges.
Yes.
Representative Elberger.
Yes.
Chairman DeSimone.
Yes.
15 to 1.
Nope. Madam Clerk, Representative Love has something to say. And what would that be, Representative?
From a no to a yes.
Thank you,
16-0.
Representative. Representative Rice moves consent without objection. No objection seen. Consent it is. I'm gonna steal that one. Okay, and don't get too excited, folks. This is the
no.
last bill of the day.
Oh,
Okay, here we go. House, I'm gonna close the hearing on of exec on House Bill 1757. And I'm going to open the hearing of exec on House Bill 1771. And I will make a motion. The chair motions ought to pass. And Representative Rice seconds. And I will speak to my motion. This bill came before the Special Committee on Childcare. There was a sunset date because it was very important to make sure that children in childcare and the ratios of children to teachers change was safe for the children. It's been in effect for a year, and we have had 0 complaints, 0 issues. So the bill has come back for us to now make it law. So I contend ought to pass because it's in the best interest of the children. Anybody else? Thank you. We're going to call the roll.
Representative Rice.
Yes.
Representative Pearson.
yes.
Representative Bogart.
Yes.
Representative Nelson.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Labrie.
Yes.
Representative Gregg.
Yes.
Representative Jack.
Yes.
Representative Scheer.
Yes.
Representative Levesque.
Yes.
Representative Murray.
Yes.
Representative Georges.
Yes.
Representative Elberger.
Yes.
Chairman DeSimone.
Yes.
16-0.
Unfortunately, it can't go on consent, but.
This cannot go on consent because it's an FN. So at the time that it comes up on the regular calendar, as long as nobody else signs up to speak on it, which I feel is unnecessary waste of time because we all agree, we'll just go for a voice vote. I thank everybody for coming today. I thank especially our substitutes. That's awesome that you come here to help us out and in respect of the people who cannot be here. Ladies and gentlemen, have a good day. We'll see you Thursday.